This video is intended to give a brief overview of your legal options. However, nothing contained herein shall be considered legal advice. This video doesn't cover all the issues you might encounter or discuss any particular issue in depth. Before proceeding with any legal decision, the best practice is to review your particular case with a knowledgeable attorney. Nothing in this video creates an attorney-client relationship. What does bankruptcy do? Bankruptcy can stop collection activities, eliminate most types of debt, and allow you to reorganize your debts and catch up on missed mortgage or car loan payments. Filing for bankruptcy relief can help you get out of debt. Depending on the chapter you file, you'll be able to stop foreclosure, repossession, lawsuits, and other collection activities, eliminate your personal liability for most types of debt, and reorganize your debts and catch up on missed payments. Stop collection activities with the automatic stay. The automatic stay is a powerful order that goes into effect as soon as you file for bankruptcy. The stay prevents most creditors from initiating or continuing collection activities against you. With a few exceptions, as long as the automatic stay is in place, creditors cannot sue you, foreclose on or repossess your property, garnish your wages, send you collection letters, or even call you to collect their debts. Certain activities, such as the collection of support obligations or criminal actions, can continue to move forward. Learn more about the automatic stay in bankruptcy. Eliminate most types of debt. The reason most people file for bankruptcy is to wipe out, discharge, debt. When you receive a bankruptcy discharge, it extinguishes your liability to pay back many types of obligations, such as credit card debt, medical bills, and personal loans. But not all debts can be discharged in bankruptcy. Common examples of non-dischargeable debts include recent tax obligations, alimony and child support, student loans, unless you can prove that paying them back is an undue hardship on you, but this is extremely difficult to do, and debts obtained by fraud. Avoid foreclosure or repossession. If you are facing foreclosure or repossession, bankruptcy's automatic stay can stop the process and provide you time to negotiate with the lender or bring your account current. If you cannot cure your default in a short period, you can catch up on payments and keep your home by filing for Chapter 13 bankruptcy. Reorganize your debts and catch up on missed payments. Chapter 13 bankruptcy, or reorganization bankruptcy, allows a debtor to catch up on missed mortgage or car loan payments and pay off non-dischargeable debts, such as alimony, child support, and priority tax arrears, through a repayment plan. Depending on your income and amount of debt, Chapter 13 plans typically last 3 to 5 years. As long as you continue to make your plan payments, the automatic stay stops your lender from foreclosing on or repossessing your property. But unless you are paying off the entire obligation, usually a car loan, through your plan, you must continue to make your ongoing loan or mortgage payments, while catching up on your arrears in your bankruptcy. If you don't make your regular payments as they come due, the lender can file a motion for relief from the stay and get court permission to resume foreclosure or repossession. Choosing the right type of bankruptcy. Your income and assets will determine the bankruptcy chapter you file. For instance, too much income might preclude you from filing a simple Chapter 7 case. Or, if you have property you'd lose in Chapter 7 that you'd like to keep, you can protect it in Chapter 13. In Chapter 7 bankruptcy, the bankruptcy trustee has the power to sell your non-exempt property to pay back your creditors. As a result, Chapter 7 might be costly if you own a lot of assets. By contrast, Chapter 13 bankruptcy allows you to keep all of your property, in exchange for paying back a portion or all of your debts through your repayment plan. Further, if certain conditions are satisfied, Chapter 13 bankruptcy offers debtors additional benefits that aren't available in Chapter 7, such as the ability to save a home subject to foreclosure or a car from repossession by catching up on missed payments, reduce the principal balance of your car loan or investment property mortgage with a cram-down, or eliminate your second mortgage or another unsecured junior lien through lien stripping. Here are a few scenarios that explore which bankruptcy strategy would be best. 1. Unemployed debtors with few assets, Chapter 7. In cases like this, A Chapter 7 bankruptcy is the fastest, easiest, and most effective means of getting rid of debt. As a matter of fact, this is the most common bankruptcy case, often called a no-asset bankruptcy. 2. Unemployed homeowners with significant equity, possibly Chapter 7. If a homeowner has a significant amount of equity in property, then Chapter 7 may or may not be the best option. If the homeowner's state exempts a generous amount of home equity, then the home may be safe. But if the state homestead exemption doesn't cover the equity, the homeowner may lose the home in a Chapter 7 bankruptcy. Because the homeowner will only be able to keep the home in Chapter 13 bankruptcy, if he or she has enough income to fund a repayment plan, it's unlikely Chapter 13 will be available to an unemployed homeowner. Employed homeowners facing mortgage delinquency or foreclosure, Chapter 13. For homeowners who have fallen behind on mortgage payments, Chapter 13 offers a way to catch up or cure past due mortgage payments while simultaneously eliminating some portion of dischargeable debt. Filers can save the home from foreclosure and get rid of a lot of credit card debt, medical debt, and possibly even second and third mortgages or HELOCs. Chapter 7 bankruptcy does not provide a way for homeowners to make up mortgage arrears, so it's not a good choice for delinquent homeowners who want to keep a home. Wealthy petitioners with a large amount of debt, Chapter 11. Very wealthy debtors often need to file under Chapter 11 due to the debt and income limits of Chapter 7 and Chapter 13 bankruptcies. Eligibility requirements for Chapter 7 and 13. To qualify for Chapter 7 bankruptcy, you must pass the means test. The means test looks at your average monthly income for the 6 months preceding your filing date and compares it against the median income for a similar household in your state. If your income is below the state median, you automatically pass and do not have to fill out the entire form. If it is above median, you must complete the rest of the form and take into account certain expenses to determine if your disposable income is low enough to file for Chapter 7 bankruptcy. In Chapter 13 bankruptcy, you propose a repayment plan to pay back some, or all of your debts over a 3 to 5 year period. As a result, you must have sufficient income to afford your plan payments each month. Further, to qualify for Chapter 13 bankruptcy, you can't have more than a certain amount of total debt. Should you file an individual or joint bankruptcy? If you are married, you can choose to file for bankruptcy jointly with your spouse, or individually. In general, filing for bankruptcy together makes sense if you have a lot of joint debts, and your state allows you to double your bankruptcy exemptions in a joint filing. However, individual bankruptcy might be in your best interest if only one spouse has debt. One spouse has non-exempt separate property that may be at risk in bankruptcy. Be aware that in community property states all marital assets are considered the property of the bankruptcy estate, or your state doesn't allow married couples to double their exemptions in a joint case. The bankruptcy estate and the bankruptcy trustee. The filing of a bankruptcy case creates a bankruptcy estate, consisting of the assets and liabilities the debtor had at the exact moment of the bankruptcy filing. The court appoints a bankruptcy trustee, whose job is to make sure that any non-exempt value in the estate goes to the debtor's creditors. Example: if a debtor files bankruptcy and owns $40,000 worth of property but can only exempt $30,000, the trustee must make sure that creditors receive the $10,000 difference. The trustee can sell the non-exempt property in Chapter 7, and distribute the funds to the creditors. In Chapter 13, the filer would keep the non-exempt property, but the trustee would ensure that the creditors get paid $10,000 through the repayment plan. What are my options if I can't afford a bankruptcy attorney? A knowledgeable bankruptcy attorney can provide you with legal advice, prepare your bankruptcy paperwork, and guide you through the bankruptcy process. But these services come at a cost. If you can't afford to pay the fees, you might be able to represent yourself as a pro se debtor, negotiate reduced attorney's fees, pay your fees through your Chapter 13 repayment plan, seek help from a free legal clinic or legal aid society, or find a pro bono attorney who will take your case free of charge. Represent yourself in bankruptcy? You don't have to have an attorney to file for bankruptcy. But whether it would be in your best interest to hire one will depend on the type of bankruptcy you want to file, the complexity of your case, and if you're willing to do the research necessary. Simple Chapter 7 bankruptcies. Filers with little or no income or assets, and no other matters that might complicate a bankruptcy, might be able to file on their own. But even a simple Chapter 7 bankruptcy requires a significant amount of time and research. If you aren't willing to make the necessary commitment, you risk having your bankruptcy dismissed. You could also put your property in danger. At a minimum, if you want to file without an attorney, get a self-help book. Complicated Chapter 7 and Chapter 13 bankruptcies. Complex Chapter 7 cases and almost all Chapter 13 bankruptcies require extensive knowledge of bankruptcy law and have many pitfalls for inexperienced filers. For these reasons, it would be in your best interest to hire a bankruptcy lawyer. In many cases, you can pay a good portion of your attorney's fees through your Chapter 13 repayment plan. Even if you can't afford a bankruptcy lawyer, consider talking to an attorney. Many attorneys provide free consultations. You could learn about hidden dangers your case might present. Negotiate reduced attorney's fees. If you can't afford the quoted fees, you can try offering the attorney the amount you can pay. The lawyer might agree to accept your case, especially if your income is low. Also, try shopping around. Other local attorneys might charge less. Talk to a free legal clinic or legal aid society. Several free legal clinics and legal aid societies assist low-income individuals with legal needs. Also, some bankruptcy courts and law schools have clinics, or information centers designed to help self-represented debtors with their cases. You can use the U.S. Federal Court Finder to find your local bankruptcy court. Find a pro bono attorney. Some attorneys take on a certain number of cases pro bono, free of charge, or at a significantly reduced rate, each year. If you don't have the means to pay for the services of a bankruptcy attorney, you might be able to find a lawyer to take your case pro bono. You can typically find more information on pro bono attorneys online, through your state bar, a local bar association, or by talking to lawyers in your area. Or start with the American Bankruptcy Institute's Pro Bono Locator. Thank you for listening.